Good morning. Welcome to LARA Live. My name is David Harns. This is Director Andrew Brisbo of the newly renamed Bureau of Marijuana Regulation.
No more H.
No more H in there. Well, no more H and no more medical.
That's true. Well, there's still medical.
Yes, but it's not in the name.
Not in the name.
All right.
Anymore.
The Bureau of Marijuana Regulation. It's going to take a minute to get used to saying that.
You'll have to forgive me for calling us BMMR still.
Right.
I'll try and change.
Down to BMR, and going to be using the J instead of the H just to, make things easier going forward? Or
I think it's sensible. You know, we try and communicate in a way that makes sense to the public at large. So even though the statute still uses the H, in our informal communication, we'll use the J. It'll save us a lot of time answering those emails about why we keep misspelling marijuana all over the website. So we're looking forward to that.
I get those quite a bit as well. And when you're citing legal citations and talking about actual acts and those things, you'll still use the H because that's required.
Correct.
Okay.
Yep.
Sounds good. And maybe let's start off. Today's the first day that the new law is in effect, and the law, when it was passed, gave LARA the role in implementing it and enforcing it and those types of things. Overall, what is LARA's role with recreational? Some call it recreational. We call it adult use marijuana. What is LARA's role?
So we'll be in charge of implementing the regulatory program for the facilities. So we have a year to start taking the applications for those facility types. We have to promulgate rules, operate the IT systems. Everything that we do on the medical side needs to be done on the adult use side as well. So there'll be a lot of interpretive guidance coming out, and we'll really start to work with stakeholder groups to have an understanding of the issues, particularly as they may differ from what we've done with the medical facilities as we start to implement the new side of the program.
Okay, sounds good. Well, we have a lot of questions this time, pages and pages of questions. I'm not sure we'll get through all of them, but we'll try. So the first one, obvious, should be anyway, when can people start growing their own cannabis plants? Now, BMR doesn't regulate the personal use of marijuana.
Correct, and that's true on the medical side as well as on the adult use side. So,
right.
The initiated law is effective today. So those protections provided for growing at home and possessing in certain amounts are effective today as well.
Okay, but BMR doesn't really say, BMR isn't going to be going in and checking everybody's plant count and those types of things. That's something entirely different, nothing to do with the license and regulation part.
Correct.
Okay. The next question, when will we be able to purchase marijuana from a store?
Sure. So we do have licensed provisioning centers on the medical side now already in place, as well as the other types of facilities under the Medical Marijuana Facilities Licensing Act. As I said when we started this, within a year we have to start taking applications for the adult use facilities. So we're going to start looking at that, start working with the new administration as soon as they're in place to determine what that timeline is going to be. So we can't predict it as of now, but people should visit our website, sign up for our email alerts regarding how that's going to unfold, and pay attention to when we put out. We'll probably do something similar to what we did on the medical side, where we'll get out some high-level information about the process and checklists for application materials before we actually start publishing applications, and either paper applications or online applications. But at the latest next December, with the infrastructure we have in place for the medical facilities, we can leverage a lot of that to move it a little bit faster. But we also have to be considerate of the fact that municipalities play a role in this as well, and they'll probably want time to determine what their approach to it will be as well.
So December 6th, 2019, 1 year from today, is the day that statutorily you have to have those applications available. You might be able to move a little bit faster, but then you also have to give deference to the locals who are still trying to figure out if they want to opt out or set ordinances or any of those types of things.
We want it to be successful in the state. We want to work with all of those interested parties to understand their needs and their concerns.
Okay. Where can I buy marijuana today? Is there a place people can go today to buy it?
Yeah, so we do have licensed provisioning centers on the medical side. They can only sell to patients and caregivers who have active registry cards, though, and within the purchase limits that are set forth. And I think that's a question we'll get to later. But we have a map on our website. If you go to michigan.gov/BMR,
yes,
you can see a map of all those facilities in Michigan.
Okay, sounds good. And you can, I think it's an interactive map. You can look for the provisioning centers closest to you, but you do need a medical marijuana card, either as a patient or a caregiver, in order to go into those stores at this time.
Correct.
And people can apply for those on your website as well.
Correct. Yes.
That should be all on the website if anybody needs information on that. Okay, and next question. can I give my medical marijuana to others if I don't sell it to them?
So that's not really addressed in the laws. There's nothing in the initiated law that addresses any carryover for products and protections against prosecution for possession limits or transfer. So that's a little bit nuanced. So I couldn't say for sure one way or another.
Okay, and so you're not the person who's supposed to answer that question.
That is correct. We're not law enforcement, so we don't determine how they may interpret it and apply it. And certainly, if someone gets charged with something, relying on my opinion on those matters is not going to help them.
Okay. A person asks, do I need my medical marijuana registry card anymore now that adult use or recreational marijuana is legal?
So that's really up to them. You know, the possession limits are similar, so they do have protections either as an adult use possessor or as a medical marijuana patient. But you know, those cards are still valid. Those cards are what's going to provide you access to provisioning centers and the retail arm of the Medical Marijuana Facilities Licensing Act. And so they need to consider what's best for them and what their use entails. And if they're using marijuana to treat a medical condition, it's likely important to have that conversation with their certifying physician as to what they should or shouldn't be doing and how they should be using those products.
What does it look like when you go into the taxes and those types of things? Is there a difference in how much you're going to pay for the medical marijuana as opposed to the adult use marijuana once that's up and running, however long from now?
As it stands now, and this is about as good as today at this point, but the excise tax, that 3% excise tax against the gross receipts of a provisioning center is repealed 90 days after the effective date of this initiated law. So March 6th, I think is how the math works out. So that 3% won't be charged against provisioning centers. On the initiated law side, there's a 10% excise tax, and both purchases are subject to sales tax as well. So in theory, the purchases on the adult use side will have an additional 10% charge in order to cover that tax.
Okay, so to boil that down, there's currently a 3% tax on the medical marijuana side of things, which goes away 90 days from today.
Correct.
And on the adult use side, when that's set up, there will be a 10% tax, and both sides have the 6% sales tax.
Correct.
Okay, and that's as it stands today.
Correct.
Anything can
there are bills pending to change, both to exempt medicinal sales from sales tax and also to change the tax structure under the initiated law as well.
Okay. Speaking of that, why are you guys already trying to take away our right to grow plants? The thing with the taxes too, the bills that are before the legislature right now. I don't think that question is supposed to be directed to you.
No, it depends on who the you guys are in that question, but it's not us guys.
Okay.
We don't write bills, we don't pass laws. That's the legislature's responsibility. So that's not within our purview. We utilize our statutory authority to make rules related to the acts that we administer, but we can't change the law. So I think what they're addressing there is the Senate bill that's pending that would adjust the initiated law, but that's not something that we have control of.
So if that bill passes, then you would go ahead and implement that bill. If that bill doesn't pass, then you'll implement the law as it stands today.
That's correct.
All right. Why are you putting limits on THC content?
So both the Facilities Licensing Act, the Medical Facilities Licensing Act, and the initiated law require us to promulgate rules to address THC content in marijuana-infused products. So we take that mandate seriously. We engage with some stakeholders. We looked at best practices in other states to establish those thresholds. So there's nothing done yet on the initiated law side, on the adult use side. But on the medical side, we do establish some guidance, and that information is posted on our website. So the current rule set in place indicates that we'll publish what those limits are. And so there's been some recent changes to that, and we put out an advisory bulletin related to that, and that's available on our website.
Okay, sounds good. There is a press release that went out earlier, I think it was last week actually. LARA is recommending a further extension for growers compared to the extension provided to provisioning centers. That's the question that we got. Mm-hmm. Why is that happening? Maybe you could just talk a little bit about that resolution. I think that's going before the board tomorrow, or maybe they'll consider it tomorrow.
Correct. So that'll be up on the board agenda tomorrow. And in essence, we're looking at some of the concerns about supply in the regulated market and trying to supplement the supply that's available through the regulated system, so those growers and processors onto provisioning centers. And so what we had recommended is a period of time in which provisioning centers could obtain marijuana products from caregivers without risk of disciplinary action by the board, and be able to sell that without having to backtrack through the testing process provided they got an affidavit and acknowledgement from the patient purchasing it that they understood that it hadn't been fully tested. And then there's an integration of that product into the upstream supply chain to ensure that it's getting tested so that that supplemental inventory can continue to provide access to products through the market and the variety of products, the volume of products, until the regulated market is fully caught up and flourishing on its own.
So you're doing this for the patients?
Correct. We want to ensure the patients have adequate access, and in particular, we've heard concerns about the variety of products coming through the processing facilities and into the provisioning centers. So we think that this supplement to the existing inventory would be beneficial for patient access, and so we're presenting that option to the board. And ultimately, it's their determination. It's not an authorization, particularly not to caregivers. What it is it prevents action by the board, disciplinary action against a licensed facility under certain conditions.
Okay, so the board can't say, hey, you can do this, you can do that. All the board can really say is, we won't hold it against you if you do these specific things.
That's correct.
Okay. All right, let's see what else we've got here. This question was a lot longer, but I'm boiling it down to, I'm planning on moving back to Michigan. How can I learn which local jurisdictions are marijuana friendly and which are not?
So we, on the Medical Marijuana Facilities Licensing Act, those municipalities have to adopt an ordinance that authorizes the facility. So we've been tracking that, and there's an unofficial list available on our website of municipalities and what the status of their ordinances are. And we've also been trying to encourage municipalities that are adopting opt-out ordinances under the initiated law to send those to us as well. So we have a handful of those.
When you say initiated law, you mean adult use, just so everybody's aware. Initiated law is the law that the voters passed 1 month ago today.
Correct.
And talking about the adult use side. And so you're saying that municipalities that want to opt out of that, you encourage them to send you their ordinance or their resolution if they do that.
Correct. And on the medical side, we have 108 municipalities so far that have adopted ordinances to opt in.
Okay. Okay, so let's see here. Is there any progress towards, now this is a little bit more nuanced towards the medical facilities that are currently up for licensing. Is there any progress towards speeding up the licensing approval denial process for applicants just on the medical facility side?
So I think we're making tremendous progress in approving those applications and getting them presented to the board. Ultimately, the decision to approve or deny is in the board's hands. We want to make sure that we provide a complete picture. We want the board to have all the information they need to make a decision. It really slows the process down if the board asks lots of questions and wants to kick it back to us to continue the investigation. So we want to make sure we do all of that on the front end. We're really working hard with applicants to ensure that we proactively answer the questions we know the board is going to ask. And a lot of the slowdown is related to how quickly applicants respond to our inquiries and how fully they answer or provide the information that we ask them for. So they play a significant role in ensuring that this moves quickly. But as we've seen on the last several board agendas, we have a lot of applications that are getting presented, and I feel like we're making real good progress. And we're also supportive of a concept of a bill working through the legislature to try and trim back the number of people that we have to do the vetting process on. And that may also help to stimulate faster processing of those applications.
And so the applicants who are applying, they have a role in this. They have to, the quicker they get back to you, the better it is for them in order to get in front of the board. That could be a slowdown process. But also, I think you've brought in, you rearranged your staff a little bit, and you've brought on more staff recently as well. And is that helping?
Well, absolutely. You know, once we get those staff up to speed, it works much faster. We have more hands working on the applications themselves. And as we've broken the process down, I think there's a better opportunity for applicants to be engaged and be notified as it moves along through the process. And I think that helps give them a sense of comfort of where they stand in the process, gives them more time to compile what we need and provide it to us without it all happening right at the end.
Sounds good. Now this question, what is the law regarding filling your Class C facility once you receive a license? Are we able to buy clones from Caregivers or only other licensed facilities?
So once a Class C facility or any grow facility is licensed, they are able to get certain materials from Caregivers. And those protections are outlined in, I think it's section 501 of the Medical Marijuana Facilities Licensing Act. And I believe it says they can get seeds or seedlings from Caregivers. So that's an opportunity, as well as until the end of 2018, they're also allowed to take in the plants from a caregiver who becomes an active employee of the facility. So there's just a little bit more time in which that provision will be effective, but that's another mechanism.
All right. What are the laws regarding buying trim for processing facilities?
So trim or shake is still just a marijuana product that's allowed to be transferred between facilities. It just needs to be tracked in the statewide monitoring system when the processor gets that from the grower.
Does it have its own category?
I believe it has its own category and metric, yes.
Okay. The November 30th advisory bulletin about the THC limits, it says that the maximum concentration per dose and per container for topicals now has no limit for products sold at provisioning centers. Can you talk about that a little bit? And then also, does the same hold true for caregivers?
So we got a lot of feedback on that topic. In the emergency rules, there was a THC limit for topicals. So we listened to that feedback, did a little more research of our own, and removed that threshold for those topical marijuana products. They're not subject to a THC limit anymore. The THC limits that we set via that advisory bulletin through the authorization and the rules pertains only to marijuana-infused products sold through the regulated facilities. So those standards that we're adopting, while we still feel that they're best practices, do not directly apply to patients and caregivers who are creating their own marijuana products. But I would advise when it comes to THC limits that patients are aware of the products that they're taking and how it suits the condition that they're treating themselves for, and to work with their physicians on whether the THC content or the CBD content of the products that they're procuring are appropriate for the treatment of those conditions.
This is probably as good a place as any to show what those three different laws are, because you talked about how you set these limits on the medical side, but patients and caregivers can kind of do what's best for the patient, right? So go through a little bit. There's three separate rules or laws, and they're effective today. They're all in effect.
Correct.
And one of them has to do with the patients and caregivers. Another one has to do with the medical, and then today the adult use. If you could just walk us through that a little bit.
So the 2008 law, which was an initiated law passed by the voters as well, established that patient-caregiver model, established protections against arrest or prosecution for patients or caregivers for certain activities, and established those possession limits for patients and caregivers. The 2016 acts that were passed by the legislature then created this retail mechanism for cultivation, processing, and sale of medical marijuana to patients and caregivers. And the initiated law now that's in place as of today kind of specifically addresses adult use. So it covers those possession limits and protections against arrest and prosecution for adults over 21, and establishes the regulatory program for the licensed facilities as well.
All right. Part of the emergency rules regarding the ability of facilities at the same location, so those who are co-located, to transport marijuana products without a secure transport was removed from the permit rules. How is that going to work?
So it was removed from the rules as we promulgated the new set, but that's because those protections, those allowances for certain transfers without the use of a transporter were added to the statute by Public Act 10 of 2018. So if it's covered statutorily, we don't need to repeat it in the rules.
Okay, so that still exists, just in a different format than this person had seen it.
Correct.
Okay, so they don't have to change that. You don't have to take your product out to the street and do a secure transporter, bring it back in, any of that.
So I think it's important for licensees to understand the statute and the rules and how they work in context. So the statute supersedes the rules. If there's something that's covered by the statute, that's there, and then we promulgate rules based on the authority in the statute, in some ways to fill in the gaps, to add certain definition to certain items. But Part 5, I believe, of the Medical Marijuana Facilities Licensing Act breaks each section down by the type of license. And so it's important for licensees to be familiar with those particular provisions as it relates to the type of license that they have.
Sounds good. Are cashless ATMs permitted at marijuana facilities?
Yes, we don't restrict that.
All right. Are square readers or other point-of-sale systems that are not integrated with Metric permitted at provisioning centers for the sale of non-marijuana merchandise? The examples are apparel or pipes or those types of things.
So those types of transactions don't have to be tracked in the statewide monitoring system if it's not marijuana products, if it's not the regulated material in those facilities. So they can use separate point-of-sale systems for those types of transactions. One thing to be aware of, though, is if you're a provisioning center, at least for the next 3 months, that the excise tax applies to gross receipts at that facility. So all of those materials that are sold, regardless of whether they're marijuana product or not, based on guidance from the Department of Treasury, those are all subject to that 3% excise tax. So the operators need to be aware of that. And the other thing to bear in mind is that the access to the area where those marijuana products are sold is restricted to patients and caregivers. So if they're selling those other types of materials in that area, they can't allow other people who aren't patients and caregivers into that limited access area, but they can separate out a different area to make those kind of sales should they choose.
Okay, that makes sense. Will LARA be implementing mandatory training requirements for workers in either the medical side or the adult use side? And if so, is there a timeline for that?
So this is another topic that derives a lot of conversation. So on the medical side, we're working with the Marijuana Advisory Panel now, which has representatives from several state departments, municipalities, law enforcement, as well as the regulated facility operators to determine what appropriate standards for that might be. So we require as part of the application process now for a facility operator that they have a training plan, and they express that to us, and we have an understanding of what they're doing, but we don't have real specific requirements on what that training has to be. That was something that we wanted input from all the stakeholder groups to have an understanding of how best to define that. So I think that's an area we may start diving into. The rule set that's in place now is a permanent rule set, but with a 2-year sunset. So we'll start working on the next set of rules that'll come in after that, and we may start to look at that in more detail. As it relates to the adult use facilities, we're going to work on that rulemaking process coming up in the next year. So that'll be a piece that, again, we'll engage with stakeholders and get an understanding of that. I think that the training elements are probably more impactful on the medical side when you're talking about giving guidance to patients on products to purchase and what the impacts may be and what's appropriate for their conditions. But again, I would go back to say that for those medical patients, it's important for them to consult with their physician about what types of products are best suited to treat the condition.
All right. So this is from somebody who just finished the appeal process with the administrative judge, and they're wondering if you know when the board will review those cases that went through appeal.
Sure. So once the process, when they finish their hearing through the Michigan administrative hearing system, that administrative law judge has to produce a hearing report that gets presented to the board with a proposal for decision. So that can still take a bit of time, and there's still an opportunity even after that draft proposal for decision is released for the attorneys on both sides to offer exceptions and make requests for that to be altered before it's presented to the board. So that process can still take a few weeks before those get presented to the board. I think we're going to start having those proposals for decision from the ALJs presented to the board very soon, though.
Okay. There have been media articles written indicating that provisioning centers will be allowed to do home delivery. Can you help explain how this is allowable under the law, and wouldn't all of the deliveries require the use of a secure transporter?
So this is the home delivery concept is something that we put into this new rule set. There's a lot of discussion about access for patients, particularly in areas where we don't have a lot of facility applicants. As we look at the northern part of the state, the western side of the state, we don't have a lot of provisioning center access in those areas. So home delivery was sort of a natural evolution of this program. We looked at it as an extension of the point of sale responsibility of the provisioning centers. The law, it authorizes only them to make end user sales to patients and caregivers. So we thought that the best mechanism to provide that. So it's all within the purview of the provisioning center. They have to submit a plan to us that shows how they'll comply with those rules for the home delivery aspect of the program. And we felt that was the best mechanism to put that in place.
Sounds good. On what date will testing regulations be mandatory? On the form that you issued recently, it's got a bunch of tests that they have to acknowledge that have not been have not occurred. Are those the tests that you're going to require?
So the testing standards are available now. Okay. That's in the rule set, so you can read those and see those there. We also have a guide for safety compliance facilities that really goes in depth about the testing, so anyone can check that out and see what the testing requirements are. But in essence, what's on that affidavit, and that what they're talking about, the form, is what a patient would sign if they're buying product from a provisioning center that's not been tested yet, should the board approve that resolution and allow for that. Those are the categories of tests that are required, and that's what's in the rules. Some of the standards, the levels to which those tests occur are defined outside of the rules, but those are all available through that safety compliance facility guide as well. Should the board adopt that resolution, the sale of that untested product through provisioning centers is only covered by the resolution through the end of calendar year 2018.
After starting January 1st, the product that is bought via a caregiver would have to then be tested, put through the metric system, and then made available not without a form, because it would be tested at that point.
Correct. So provisioning centers, if the resolution passes the board, if they procure caregiver product during the month of December, it all has to be tracked and metric. I want to make that clear. It's got to be put into the statewide monitoring system before a sale is made. Any sale made through a provisioning center has to be sold with product that is registered in the metric system. But during the month of December, they can sell it without the testing in place with that acknowledgement by the patient. Starting in January, still all tracked through metric, but it all has to be tested prior to sale.
All right, and this again is for the patients while you're doing that.
Correct.
Okay. So a little bit more about the transition process now between medical and recreational. Again, we call it adult use, but can you briefly discuss what the application process will look like for a cannabis business license on the adult use side?
So I think there's a lot to be defined there still, and I would encourage folks again to stay in touch with us, look at our website, follow our advisory bulletins and our press releases and our email blasts to see how that's going, but more information to come. I think, again, we'll leverage a lot of what's in place on the medical side already, but we'll have to look at, you talk about micro businesses, that's a new concept, so that will have a new application process, but we'll be sure to continue to communicate that information as it gets formulated.
All right. If an entity receives any one of the 5 license types on the medical side, will they automatically be grandfathered in for the same license type on the recreational side, or will there be another laborious and expensive process that will be required to secure one of the 5 licenses on the adult side use of the business as well?
That was a long question.
Yes, it was.
And with some pretense there.
Yes.
So a license will be required for a adult use facility. It will be a separate licensure process. But for the 5 sort of analogous license types that are authorized under adult use, that are comparable to the Medical Marijuana Facilities Licensing Act, I think we'll be able to streamline that process because we will have done the in-depth background investigation on the associated individuals. What's going to be necessary to make that work as quickly as possible is that the ownership structure of that entity that's applying on the adult use side matches what was in place on the medical side. But that will save us a lot of that effort on the background piece.
That makes sense. Does LARA have an expected time frame for coming up with the application licensing process? Let's see here. Or again, will preferences be given? So I guess you kind of answered that. Would the small entrepreneur who's looking to be integrated into the industry be given any consideration?
Yeah, so I want to go back to the fees for a second. I want to make it clear that the fees that we collect, both on the medical side, and we have the same language essentially on the adult use side, those fees are only what's necessary to support the operation of the program. The regulatory assessment on the medical side also funds several other statutory mandates, but while it may seem expensive, what's important is that the fees being charged are supporting the operation of the regulatory program. In terms of access to the licenses, the adult use statute, the initiated law, sets forth requirements that will be in place for up to 2 years, mandatory for at least a year, that kind of restrict eligibility for certain license types. So for these small businesses, the Class A grower and the micro business, those are eligibility for those licenses is restricted to Michigan residents. For marijuana retailers, processors, growers, Class B and C, and secure transporters, eligibility for those licenses is restricted only to operators that have a license under the Medical Marijuana Facilities Licensing Act, and then safety compliance facilities, that's wide open. Anyone can apply for that license.
All right. The next question comes from a city commissioner. I've been advocating for our city to allow medical marijuana retail, grow, and research facilities. Some think that if we allow medical, we have to allow recreational. Could you clarify this? If we allow medical, and then when the recreational laws are in place, if the medical provider wants to sell recreational, would we have to allow them?
So I think it's important that municipal officials talk with their legal counsel about how to implement these laws and what the impacts may be. I don't want to give them guidance. I'm not their legal counsel. We do recognize that on the medical side, there's very clearly an opt-in provision to allow for the facilities in the municipality, and then it's sort of the flip under the adult use side where they have to prohibit them if they don't want them to be there. How the interplay of ordinances that may authorize it on medical if they want to opt out on adult use may go, I think they're going to have to take a good strong look at that and make sure they understand what their approach is and what their legal defenses are if that's how they want to implement it.
And in that regard, if a township or a city opts out of the adult use side, they're only opting out of the facilities aspect of this. You can't opt out of the allowing 12 plants per household and 2.5 ounces and those types of things, right?
Correct, and the same on the medical side, that the patient caregiver model exists under its authorization in the 2008 law. So really all we're talking about when it comes to those municipal ordinances are the retail facilities, both on the medical and the adult use side.
Okay. And how long will it take LARA to promulgate rules and make license applications available? I think you kind of answered that a little bit.
We definitely want to start working on it now. We have to engage with the stakeholder community and the new administration to have an understanding of what the issues are and how we can best address those. But I can assure you we'll be in place by December 6th as is statutorily mandated. But the rulemaking process, we'll try and get that information out so that everyone's aware of what those requirements are going to be as soon as we can.
All right. Then it's kind of the same question, I guess, but this one has a little caveat. In particular, I'm concerned with situations in which an existing medical operator has facilities within municipalities that have opted out of recreational cannabis. Will those operators be able to apply for licenses to be used outside of their current locations? So
the language in the initiated law, that's the adult use law, simply says that eligibility for those license types, as we mentioned before, is restricted to persons, legal persons, so think business entity, that has a license under the Medical Marijuana Facilities Licensing Act. That's all it says. So that's what we know now. It doesn't appear to have any restriction to the specific site. But the adult use law does indicate that we can't restrict facilities from being co-located. So that's really what we know at this point. I think probably more information on that will be forthcoming, but there's no specific tie-in to a location specifically.
When you get into the nitty-gritty of these things, it's a little more complicated than it looks like on the surface.
Certainly. You read it through the first time and you think you have it all down, and when these questions start arising, it causes you to look at it a little bit differently.
Exactly. All right, so on the recreational side, the adult use side, can you explain what a micro business is? That's a new term that's just gone into effect today.
Yeah. So the micro business is sort of mandates vertical integration. Vertical integration means they're doing all facets of the supply chain at a single facility. So the micro business would allow a licensee to have up to 150 plants, but they would have to do their own processing and their own sales through their marijuana retail operation. So they couldn't grow it and sell it out to another facility, and they couldn't buy marijuana products from another regulated facility. They do it all themselves, but they could engage with the safety compliance facilities for testing, obviously. But it's sort of a boutique, small operation where they grow, process, and sell their own products.
But the testing is required?
It's not clear in the statute, but I think, for the sake of public protection, we'll want to ensure that we have good testing standards for any end products that are sold to consumers.
That would be via rules.
Correct.
Okay. Will industrial hemp be recognized as a separate plant from marijuana, allowing for the cultivation of hemp in Michigan? And then another question, anything you can tell us about hemp would be appreciated.
Hemp is my favorite topic, such a nuanced and odd issue. But so the ballot initiative, the initiated law, adult use law, does have language about legalizing industrial hemp cultivation, processing, sale, and so forth. That's really all it says. So it certainly provides some legal coverage for that and permits the department to adopt rules to address a regulatory program for that framework. Obviously, we have no rules in place for any of that yet. So I think it's important to stay tuned to see what comes of that. There are also some bills working through the legislature now to create an industrial hemp regulatory program in the Department of Agriculture and Rural Development. So it'll be interesting if those bills continue to move and if that law passes and that changes the Industrial Hemp Research Act, which is already on the books, how these laws then will play together.
You seem like you have a lot of balls in the air when it comes to this type of stuff. You have a lot of hemp and marijuana and all these things. You have to keep track of where they're at in the process and all of that.
And when you're looking at statutory interpretation and application, it's not, the laws don't always agree with each other. You have some conflicts, you have some challenges to work through, and that's where it's important to take an approach where you step back, you really look at that to make sure any guidance you're giving is accurate and is supported. And when you have multiple state agencies as well as law enforcement that's involved in all this, it's important to make sure everyone's on the same page. So sometimes when we're a little bit roundabout or evasive with answers, it's simply because I can't provide direct guidance because we don't necessarily completely have the say in what all this means and how it's going to be applied.
But you do a good job of getting out there what you do know, and I think people appreciate that. What are the vehicle laws? If I can gift my recreational harvest to a friend or a patient that lives in Michigan, is it then legal for me to transport it to him or her? Is the limit 2.5 ounces in my car? Do I have to go through a secure transport company? I know this doesn't necessarily fall under your purview, but I know you've read the law quite a few times. Maybe you can give some advice, but knowing that it's just from the law what you've read.
Right, and you know, the law doesn't always address every situation, so that can be challenging. There's not always a direct answer in the statute. And unfortunately, in those cases, sometimes you have to wait for the courts to hear cases and make decisions to understand how to apply some of those provisions. But there is a 2.5 ounce possession limit for a person under the adult use law. You can have up to 10 ounces at home, but anything over 2.5 has to be secured. And there is a provision that allows for the transfer without money exchanging hands, and it can be advertised of up to 2.5 ounces, but no more than 15 grams of concentrates. So that's what the law provides for.
That was a question that we had down here. Can patients and caregivers gift raw cannabis products, or cannabis plants to adults over 21? That's what you're talking about, the 2.5 ounces, 15 grams of concentrate,
Yep.
But you can't advertise the fact that you're doing this.
Correct, and you can't, there's no remuneration allowed at all.
You can't pay for it.
Yep.
Fancy word, remuneration.
Correct, I'm sorry.
Yeah,
That's what the law says.
Okay. All medical plants and recreational plants have to continue to be in a locked area. I guess that's a question. Or does only the finished product need to be locked?
Nothing changed on the medical side.
Okay.
So the medical side still has that same language for a patient or caregiver, that if they're growing at home and if they have products, it has to be in a secure, locked facility. I don't think the adult use side says that about plants, but it does say if you're possessing over 2.5 ounces of usable marijuana, that it has to be secured and locked.
Okay.
And actually, I think it does say on the recreational side, it can be visible from any public area and has to be secured. So
Okay.
I think it's important that anyone that wants to do this, you really should read through the law,
Yeah.
see which provisions apply to you directly, and have an understanding about what it says.
Yeah, and again, like you said, the law does not address every single issue that could come up, or every single conceivable question that could come up.
That's true.
Once my medical plants and recreational plants harvest, what are the limits? Do the caregiver medical law limits apply? Does something else apply? Do I just get to keep everything that my plants grow? I don't think that's the case.
No, it's so both laws, the 2008 law, the Michigan Medical Marijuana Act, as well as the adult use, do have possession limits, and neither of them has any reference to the other as to whether the possession limits apply or not. I believe the adult use law does say something that nothing in it is intended to undermine the protections of the 2008 law. So I think that can be looked at as meaning that you can stack those possession limits, but I wouldn't rely on my guidance to say that. I think it's important that people read that themselves and maybe speak to their attorney about what that means. But there are possession limits both for plants and for products at home and on your person in both of those laws. So if you're a medical marijuana patient, you're also over 21, or you're a caregiver and you're a patient and you're over 21, I think you need to look at all those things and consider your individual circumstance and look at those limits. And, it could be subject to scrutiny by law enforcement. So ultimately, you'll need to have an understanding of what your arguments are as to what you're doing and why it's legal.
So these plants don't automatically produce the amount that's allowed by law.
As it turns out, they don't.
They don't. It's like there's no magic plants that do that.
No.
Okay. Let's see here. We've answered most of these questions here. I guess this one, did you answer this one? Will patients and caregivers be able to possess the maximum amount of usable marijuana under the MMA? In addition, yes, you did. You answered that one.
Yeah, it's again, the laws don't really speak to each other as to how exactly that's supposed to work.
All right.
And there's another question up there about.
One last question. Let's end on this one.
Okay,
this one's a good one.
Fun one.
When is it considered a plant? If I take a cutting and it doesn't have roots yet, is that still considered a plant, or does it have to be in a container? And I'm guessing you're going to say, don't take my advice on this, but.
Well, for regulators such as myself, the most important part of statutes are definitions, because legally you can take a term that's used in a statute and define it however the legislature chooses. So the Medical Marijuana Facilities Licensing Act has a very specific, distinct definition of what a plant is. When something you put in the ground becomes a plant by definition, and that's when it's creating its own food through photosynthesis and either has observable root growth formation or is in growth material. The adult use law does not offer any definition of what a marijuana plant is. So I think it's going to be something that has to be discussed, and there may be court cases that determine when it becomes a plant by definition. But for the time being, the only definition we have to work with about what a marijuana plant is comes from the Medical Marijuana Facilities Licensing Act.
All right, sounds good. Well, 43 minutes later, I think we got through a lot of these questions.
It's a long half hour.
It is. Thanks everybody for joining us today. We hope to be back with you again soon. Take a look at the website, the newly designed website with the J.
Michigan.gov/BMR.
Yes, no BMMR. Although if you go there, you'll still get there. But yeah, somebody said to me today, "Hey, you're less of a bummer now."
BMMR. I am, huh?
Yeah. So, all right. Well, thanks everybody for joining us.